And so here's a situation. You're stuck in a catch-22 between 6,000, 20,000 to settle. And then the next thing is, if you don't settle, you're going to get slammed with discovery because they have you written discovery, because that's the way the American system works.
Welcome back to the My Wife Quit Her Job podcast. Today, I'm thrilled to have Steven Weigler back on the show. Now, Steve is my go-to guy when it comes to trademark and IP protection, and I've used his legal services on a number of occasions. He is the founder of Emerge Counsel, which recently got acquired by Bookhalter, where he helps e-commerce entrepreneurs protect their IP. Anyway, the reason why I brought him back on the podcast today is because I've been getting a ton of questions regarding the increase in frivolous lawsuits hitting e-commerce entrepreneurs, especially in states like California and New York, which is where I reside. And we will also cover different ways to protect your IP as an e-commerce entrepreneur as well. So with that, welcome back to the show, Steve. How are you doing today?
Life couldn't be better. Yeah, everything is good.
Can we just start with what the issue is? Let's just assume that the people listening know nothing.
The issue evolves around privacy. And so privacy is in the world of e-commerce and in the world of internet transactions involves what information you're collecting from the person that is interested in your particular website. And this is particularly acute, meaning it's like showing up a lot in Shopify transactions. And why Shopify is because Shopify is really it's very much a backbone that you design your site and you control your site. When you're selling on Amazon, well, that's completely on their platform, and how they're collecting information, et cetera, is run through Amazon protocol and processes. In Shopify, you have a lot more control on what you put up there and what you don't.
I just want to provide some context for the people listening. I actually got a letter not too long ago, and it wasn't even for my e-commerce business. It was for mywifequitherjob.com, saying that I was illegally collecting information from a Facebook pixel for meta ads. And the kicker here was I'm not even running meta ads. Like, I have the pixel on the site, but I wasn't running meta ads at the point of the lawsuit. And so these are the types of things that and if I go through some of my e-commerce communities, people are getting these letters left and right for just collecting information on your website, which is something that every e-commerce store and every online business does. So just wanted to set the background here. Yeah.
Right. And keep in mind, audience, that these are all frivolous lawsuits.
Yes.
I'd say 99.9%. And from an attorney perspective, again, proactive measures so you're not going to hit their algorithms when they're running their software is much better than dealing with the frivolous nature of the lawsuit, because why they're focused on, and we'll go through them really quickly. The California is called the CIPA. The Florida is called the FSCA. Texas has a bill, Senate Bill 140. And then, as Steve referenced, like New York, there's other state laws. Each one was not, these laws were not written for e-commerce transactions and privacy. The California law is specifically focused on wiretapping, and it was derived in the 1970s. The Florida law has to do with online collection of data, mostly in the healthcare space, if you look at the legislative history. And so these have nothing to do with e-commerce, but in law, the plaintiff's attorneys, and my experience is you're not talking about the highest echelon of plaintiff attorney. They're looking for loopholes in the laws, and they see the easiest loophole is when you're an e-commerce, and this is a generalization because each law is different, but when you're an e-commerce seller, if you're collecting data, like for example in a chat box, and you're not telling the user what you're using it for and how it's going to be stored, or that you might be collecting sensitive data, it's just they're plugging it into this statute and hoping that the nuisance value, meaning that you'd rather pay them off than litigating this all the way to, say, the Florida Court of Appeals, because it's settled law.
So you mentioned earlier there's prevention and staying under the radar. Mm-hmm. What are the steps? Like, how could my situation have been avoided?
Sure. So number one, there's best practices, and I
Okay.
prepared kind of a PowerPoint style um, presentation showing what the best practices are.
Wow, it
And
sounds complicated.
yeah, I mean, no, it's really actually very
Okay.
easy. You just look at
Okay.
like, yeah, you look at, for example, go to any major Shopify seller, et cetera. Look at how they're doing their chat room and what the
Okay, so hold
protocol
on. So you mentioned chat room. Is that like the main issue or
for Florida it is.
for
Um,
Florida? Okay.
okay, so let me just pull up the some of the examples that I have.
So in my
Um,
case, it had to do with a metapixel. Like, I mean, what can you do? Did you just put something in your privacy policy or terms and conditions?
yes, but you have to. So the best privacy policy is one that pops up and that they have to accept all cookies. So you look at the any major e-commerce seller or any kind of seller is you look at their site and you see that the there's a pop-up and it's an opt-in, like you to continue on you have to accept the cookies,
I
or you
rarely see that, even in the largest Shopify stores, actually. Rarely,
yeah,
because it's
well, I
intrusive.
mean you that that is best practice. And so there's
Okay.
three ways to do it. Again, if you contact me, and we'll talk about my information at the end, I will gladly um, send you the examples and also send
Okay.
you the I'm available for free. Just call me and we can walk through it.
Okay. So the pop-up with the accepting all cookies and privacy policy, all that stuff, most people probably are not going to do that. Like you got to weigh like the pros and cons of the chances of litigation versus putting up a pop-up that's pretty intrusive on the site, right?
Right. So what I did in my PowerPoint is there's best, second best, third best.
Okay. Sure, sure, sure. So is that the
Sure.
best on
Yeah.
the list?
Yeah.
Okay.
Again,
All right.
because what we're trying to do is get around the algorithms.
Okay.
Because what a plaintiff's attorney in so let's go through the various
Sure.
scenarios in California. It's there's where there's the most litigation. We're looking at between 50 and 100,000 CIPA e-commerce claims filed since 2022. We're mostly seeing them in Northern California, although all the ones I've had are in Southern California for whatever reason, and in San Diego. And why that is because they forum shop. They look for the judges that or the circuits in California that haven't um, definitively ruled on this.
I
The
mean, if I
courts,
were a evil lawyer, what I would just do is go down the entire list of Shopify stores and just send them letters, right?
100%.
Yeah, and that's probably what's happening. Okay, sorry, I
They
didn't mean
send
to interrupt.
letters, but what they do is so to file a claim in California, don't quote me on this, but it's about $250.
Okay,
And and because I've had a number of these, you can look at the plaintiff's attorney and you can look, they go and file like 20 in a day, 20
right.
times 250. They know that and payouts of, and then they're generally requesting or demanding between 6,000 and $20,000 to
Jeez.
settle.
Okay.
And you're stuck in a, and so here's the situation. You're stuck in a catch 22 between 6,000, 20,000 to settle. And then the next thing is, if you don't settle, um, you're going to get hit slammed with discovery because they have pre-written discovery because that's the way the American system works. And that costs money. You can't, and I wouldn't suggest you do that yourself. You need, counsel to help you. And, so 6 to 20. And so you get slammed with discovery. Then the trial court, we've seen trends that the trial courts are starting to not wanted to deal with these because they look at it like a docket. Well, they have a docket. If 200 cases just got entered on their docket, they want to get rid of the 200 cases. So they want to create laws or precedent that they're going to find these cases frivolous. But you have to file what's called a motion to dismiss to get to that far, and it might even have to be you might
Okay,
have
let's
to.
not talk about the consequences of getting one of these lawsuits just yet. So, what was the number two prevention?
So the number two prevention is to have a disclaimer up on top, like if you're and they just click OK.
Oh, sorry, a disclaimer on top of where?
on top of your website.
On top of the website,
Yeah. So
like on
you're
the front page.
on the front page, right?
Okay, forget
And
that.
it's
That's as intrusive. That's more intrusive than the first option.
well, the first option is that you're actually having to manipulate cookies because and you've seen those policies where it's
Sure.
all cookies. I accept all cookies. The modification of cookies, or I decline cookies.
So I'm sorry. This disclaimer method. What does it say?
It just says that you might be providing confidential. We might be taking in confidential information,
Oh
and
my goodness. Okay, and then they have to close it, or does it have to stay displayed?
no, I mean I think I have a number of different ways you can show that, but usually it's what it is what makes a good policy is that they have to do something in affirmation that says they saw the thing. And so
I see. Okay.
an okay on the right would be the second best. And the language, again, contact me and I'll give you what I think the best language.
By the way, if you're interested in starting your own profitable online store, make sure you sign up for my free 6-day e-commerce mini course below. It's 100% free, and I guarantee you'll learn a ton. Can we just put this in the privacy policy or disclosures page? That's not good enough?
See, it is for most privacy litigation that I would advise you on. We're not sure about in the CIPA because this is untested litigation.
There's no way I would put any of those things on my site. Like a disclaimer that says we're collecting confidential information about you. I mean,
right. Well, we would
modify
it to
even still, like that reminds me of this restaurant I went to once, and this is in California, and there was a big sticker right on the door that said, some of the ingredients used to cook your food has been known to cause cancer or something. I'm like, what? I mean, that almost made me not want to try the restaurant, even though I know
right.
it's
Well, that's it. Look, Steve, like California is a unique state because you're talking about Prop 65. That's another issue that e-commerce sellers face in California. If you don't put that, like for example, you have supplements. I had a client that had rare earth supplements, e-commerce seller. Rare earth meaning they derive from, I don't know, some kind of rock or something.
Sure.
I would never take these supplements. It sounded scary to me. But the rocks had trace elements of lead. Trace, I mean, we're talking trace. But in California under Prop 65, you have to have that disclaimer or you're subject to liability. So you either do it or you're a prime subject for liability. That could be a whole nother webcast. But California is strange. But in this particular Prop 65 is a whole nother issue. But in the CIPA, what's interesting about it, and again, you can take the risk because it's not settled law in California.
Right.
Remember that this has to do with wiretapping, like serious, like Watergate kind of stuff. And it derived from water. So, and for those of you who don't know, Steve's brother is a appellate attorney. I'm an appellate judge in California. This is what he is responsible for, and at least in this particular
I should ask him.
Yeah,
I didn't realize
we're deciding this because there is not settled law on whether the CIPA covers e-commerce transactions. And
okay, I have more questions for you, Steve. But is there a number 3 before we get into my?
Well, the number 3 is to put it in your privacy policy, but make your privacy stick to your privacy. It's an opt-in that I reviewed the privacy policy.
Right. Okay. And I remember for the privacy policy, like I have a number of, like my privacy policy is like really long because every little service that I use, they have me cut and paste, like for example, when I installed SMS, text message marketing, there's like this whole long thing that they just have me cut and paste in there, just as one of the guidelines to even sign up. I did not have anything.
I think it's like an opt-in versus an opt-out. And then, you would make sure that your privacy policy is covering the major ones because we're seeing the major unsettled litigation is in California and Florida, Texas.
Okay.
So we know that there's 20 states with these types of laws. Most are going to, like if it were in Colorado or Massachusetts, they'd probably be thrown out. We're seeing varying responses from the California courts because, some people either have the money or, meaning some defendants, either have the money or just are like, this is BS, and they take it to the mat. And so what we're trying to do, like I have one in Florida right now, we filed a motion to dismiss in the hearing. I'm a Florida licensed attorney, so I can do this. The hearing is in, I just got the email today, is September 30th. I think I have a good chance of getting rid of it. The plaintiff's attorney might even drop it before he has to, be embarrassed in court. And let's go through the Florida one real quick, because that, as a segue.
I mean, is that the norm for these to get thrown out? Like,
No, it depends on the jurisdiction. So what we're seeing,
you've had cases where someone has been found guilty and they had to pay a ton of penalties over 6 to 20K, which is what.
So in California, which Buckhalter, the firm I joined, has a large presence, we've seen varying success depending on the jurisdiction. Most of the time, we have attorneys that are handling this like 24/7.
Okay.
And so again, that's a warning sign for the audience here, is like, this isn't fiction. I can find out, but I don't believe this firm has taken cases to trial, like jury trials. But we've seen that, we know, I did a study, one case in California with another law firm, it went to jury trial. The defendant lost, and it's now up on appeal. And so we know that
Okay,
happened.
so they are taking this lawsuit seriously, and there have been losses. For
They have
internet Shopify store. Was this a Shopify store?
Mhm.
Or just an internet company? Okay.
I don't know. I mean, meaning I think it was an online internet company, and we know it wasn't like a
Sure. And they probably screwed up and didn't have anything in their privacy policy. I'm just trying to understand like how worried I should be about this. Because if it's like $6,000 versus putting a big pop-up on my site or a big disclaimer that says I collect your information confidentially, I'm probably going to take that risk of the settlement, right? I don't know. That's just me.
Well, that's $6,000 plus. Again, this isn't when you get served with a lawsuit, it's usually not amateur hour, meaning don't try to respond to this yourself, unless one thing you could do is call the plaintiff's attorney and say, what are you looking for? But it's going to be, if you call as opposed to me call, it's going to be 12,000 for you, 6,000 for me. They're like, sure. Yeah. So the point is you're going to need to hire a counsel, and so add a couple thousand to try and get this resolved.
Okay. So if you are served, you definitely need to hire a consult, a lawyer, or
please. I mean, look, you guys, if you're served with any kind of lawsuit, maybe except a small claims court, like you have a $2,000 dispute or something, please call counsel. If you want to call me, no cost to review it. I want to make sure that this is well handled. That is essential. You get served with a lawsuit, it is serious.
Okay, so let's say someone has been served one of these. Like, what's the next? Like, how would you handle this? I mean, it's totally bogus, right?
Yeah.
So
both in California and Florida, we have studies on and software to figure out how many of these the plaintiff's attorneys filed, what's happened to each one, because it's not one size fits all. These are attorneys that they found out about it. This is all they do. And so, and usually, again, not the upper echelon of attorneys. This is not, these are ambulance chasers, but in the privacy space. And so, and it's interesting. We also have information on the plaintiffs that are filing these. It's always, so I have one in Florida right now. Her name is Monica. She's filed 15 lawsuits, 12 related to this, one related to that Sears or some retailer was supposed to deliver in their terms, their delivery terms on the internet. They were supposed to deliver within a window or call her, and they called her 10 minutes after there was the window. So like, these are serial plaintiffs.
Got it.
And scummy attorneys. I hope no plaintiffs attorneys listen to this.
So the chances of you winning are pretty high, it sounds like. Or...
depending on the facts. But yes, I think it's not, number one, we're monitoring what this attorney rate is of taking these to trial, what the attorney's rate is. If we can figure out the settlement amounts, you can just call the attorney and they'll tell you that. But we're getting a lot of background information on how to handle these. And then based on and then we're monitoring the jurisdiction. So for example, Steve, in Southern California, mostly San Diego, we're seeing a lot more of these being litigated, meaning the courts aren't throwing them out as much as we are in Northern California in your jurisdiction.
Okay.
Like the courts are like, listen, I have better things to do. If I'm wrong, the appellate courts will turn that around.
Let me ask a dumb question here, because I know very little about the law. Let's say you do settle.
Mm-hmm.
Can you just get hit with another lawsuit from a different plaintiff?
Yes.
Okay, so there's no, okay.
Yeah, so that's why we're looking for best practices. And again,
I don't like your best practices, though. I mean, is there?
I know, but Steve, I mean, we'll custom tailor one to you that's at least better than what you got now. And I haven't looked at yours, so I'm not saying you don't.
Sure. Yeah, I know.
But it's going to have buzzwords like we comply with the CIPA by ABC. I mean, in other words, like there's just some key language that at least will be better than, just glossy sticking it in your terms and saying we're collecting this data and there's no indication that anyone can even find it, because it's not that that's wrong or right. It's that it creates a question of fact. Like, is the consumer able to see that? And that creates ambiguity, and ambiguity creates litigation. And these people, again, it's not the litigation of the century. They're not looking for, several $100,000.
Sure.
But it's nuisance, and there's a risk. And again, Steve, we hit that same thing with you referenced Prop 65 with this has a minuscule amount of magnesium or something in it, and it causes cancer. If you don't do it, and they find you and they care, ambiguity by not doing it creates issues.
Okay, so it seems like the logical course of action here, Steve, at least in my mind, is to maybe have you review the privacy policy or the terms, right?
Yeah, or just the website. Yeah. And then again, I can show you best practices, your audience, best practices just by contacting me, email me, I'll email you those back. And then, 5 minutes, it's not going to take much of my time.
See, I think that's the right course of action.
That's much better than getting the legal bills that I'm creating from having to deal with these. I don't like ambiguity. I mean, it's my job, but I don't like ambiguity as much as than you. I mean, meaning it's like, who wants to be the person to test the CIPA? And what the analysis is, especially in California, is a legislature needs to fix this. And because the law is ambiguous. And same with Florida. The law is so ambiguous that it requires a legislative fix to, because the courts don't know what to do with how the law is written. It's written so broadly. And the legislative fix, it got killed in the California legislature this last year for some political reason. Surprise, surprise. And in Florida, they're just starting to deal with it. So we're just in a land of big ambiguity, and plaintiffs' attorneys are taking advantage. So I agree with you. The best way to handle this is to find the best practices that you can live with and that aren't going to require major changes. And if, the cookie management policy, you have some listeners that are so strong on the internet that we've strongly advocated for that. And they have, or even without us opining, they have those, very definitive cookie policies. But it's not a one size fits all for everyone, for sure. And, I've been also trying to monitor the Shopify site, meaning the mothership, to find out what their advice is. And that's been, they don't have any real liability there. So that's been a little ambiguous. But they're aware that, these lawsuits are happening, and a lot of e-commerce sellers will come back to them and why'd I get this lawsuit? So they're aware of it and taking action too. And my next step is I'm planning to contact, Shopify Counsel, because I have some connections there, and find out what their best practice is, including me. We'll do the thing. option A, like to make sure you're bulletproof. But I'm also realistic, having my own company, that you have to have run a business like this, and this could be just a nuisance suit. But who wants that? And again, we're trying to get to the point where at due diligence, this is going to come up. Like did you have any lawsuits in the last 5 years? How can you answer that without saying, yes, I got sued for CIPA and had to settle?
Right.
If I were the buyer side, I'd say, I don't care about that. But not everyone's like me.
Okay, so it seems like the action item here is to get you to review the site. And it says, and you mentioned before, anyone can contact you for free. My
Yeah.
next question, remember I had you on, like, was it last year or 2 years ago, where we talked about like ADA lawsuits? Remember that? Kind of just went away over time because there was some court case that where they just threw it out, and that was like the precedence for people not winning these anymore. How close are we to that with this? Because it's like the same thing in my mind.
Yeah. At the moment, we're monitoring it. The moment there's either a legislative fix in California and Florida, we're going to let you know. It's too early to tell.
Okay.
And it might be a question to ask your brother. We might be seeing an opinion with your brother's name on it. So it's in the appellate courts right now. Then ultimately the legislature, we know in California, is aware, because this affects the general business community. I mean,
Well, it affects anything on the internet, basically.
yeah, exactly.
It
So
includes apps, everything, right? I mean, it's like endless.
yes, and so the lobbyists, which deal with the legislature, are pounding the legislature to change, to tighten up the law.
Okay.
And then the question is it retroactive, is it proactive? But I have a feeling we're headed in the right direction in California. In
Okay.
Florida, which is kind of a different issue because the statute's different,
Right.
is more about chat room. And so
Let's talk about that, because I kind of glossed over it earlier. What do you mean by chat room? Do you mean like a live chat or like
live chat, yeah. So
live chat? Okay.
yeah, so live chat. And so in Florida, so in certain states you require, like in Colorado, if you called me and I want to tape, like I have Plaid, PLAID, and I want to record the conversation, as long as I consent, record away. You don't have to, I don't have to tell you, you don't have to consent. Florida is a 2-state consent state. And so you have to consent to all communication between parties.
Okay.
And so you figure, and so Florida, but when you do a live chat, it's between you, and then it goes to a third party, and then it goes to the seller, right?
Right.
It goes. And so the argument that the plaintiff's attorneys have is, you didn't tell my client that the third party was going to get the information.
I see.
And so, and that these started in 2020. So there were 5 cases in 2021, 28 cases in 2024. And now we have hundreds, if not thousands, of cases filed in Florida in 2025. So the law is slow. And Florida is no different. And so there's cases, and this is a motion to dismiss that I have going on. My client has a chat that says, we are recording this chat, but we're not saying who we recorded, who's we. In hindsight, meaning I wasn't involved, but what would be required there is just a better kind of post above the chat. And I think that's, really pretty fixable.
Okay, that's a pretty easy fix. You can just say, this chat might be recorded for quality. Would that be good enough?
I have the exact language. I won't bore your audience by writing it. But the problem, again, the problem for everyone else is if you're not one of the few that knows what's going on down there, you're a target. So I think the easy fix is you do live chat, you put up this post, and pretty much about Florida law and saying, these parties are involved and you're consenting to this, or don't ask, don't get involved. It's a little, it reads so much like legalese that no one's going to pay attention to it.
Right.
The problem with Florida right now is number one, it's there's no real law on point. And the other problem is that what they're doing is they're filing it in what's called county court, which means it's like for damages only up to $50,000, or I think, $50,000 in Florida. So that's kind of minor league court. And it's not real big on procedure or handling major issues of law. And so it's just, but why they're doing that is because it's the amount. So say they get $5,000 plus attorney's fees,
right,
is written into the Florida law. So it could be hundreds of thousands of dollars of attorney's fees. And so that's a very scary proposition, and why these cases are settling. But my case, what I did is I set it for the latest possible hearing I could get. And the person, I told you, this is the Monica person, she filed 15 lawsuits in one day. So I'm seeing how the other 13 go before my hearing.
Seems like we should dox this Monica person, but no.
Yeah, exactly. Well, I mean, there's so many. If it's not Monica, then it's going to be Nancy. It's like it's just a whole nother world out there.
Let's talk about just kind of like action items here. Like I can tell you what my perspective is. I think the simplest thing is to just have you review like the website and the privacy policy. And then if you do get hit with one of these lawsuits, which chances are someone listening has probably gotten one of these, they need to find console basically. Okay.
Right away.
Okay.
Like my suggestion, you can try and call the plaintiff's attorney, but they're going to, it's like going into a car dealership. They're going to tell you what
you don't want to go there because they're yeah.
So but if you had a consulting service buy the car for you, and
then scale of 1 to 10, because I always like to know this too. Like, what are the chances right now? You said there's 100,000 of these happening
in California. Yes,
just in California.
Yeah, because these are
how many? Yeah, how many of those are Shopify stores?
2022. I don't know, but I would. There's been some consolidation in that platform. Most of them are. And we know that if they're not Amazon sites or Walmart sites, because Walmart has good cookie policy.
You went through the whole ADA thing. On a scale of 1 to 10, what is the worry level on this to take some preventive action? I'd
say a 7, because it is so weird. The clients, and they're we know who these people are, because you've some of them are your students.
Okay. Yeah.
These are best practices people. These are some of my favorite clients. Okay. And so they've done nothing but good business practices, and it's random who gets these suits, and very random. And I think it's a software play on the plaintiff's counsel's part. I think I know the software that can do this. So yeah. So I think it's very high compared to an ADA, which I would put at, a 2. I'd put this at a 7 to 8. Okay.
So maybe what we'll do is, what is your contact information? You want to just tell that to me?
So you can contact me always text me on my cell phone, 720-480-8204. That's 720-480-8204, or email me at SWEIGLER, and this is a little hard, at BUCHALTER.com, or just Google me.
Okay.
And you find all that information.
Yeah, you mentioned you had a PowerPoint of best practices.
Yeah, sure.
Are you going to share that? Okay. Mm-hmm. Okay. Yeah. Maybe we'll turn to a PDF and share that too. I hate dealing with this stuff, Steve. Seriously, like, me too. And I love you as a person, but like, whenever I have you on, it just causes unnecessary work. Like, you know what I'm saying? Because these are just like frivolous. Like, I had you on last time for day, and just made me angry as soon as we got off. Not at you, obviously, but just that
No, and
stupid thing.
this is only 20% of my practice. What I want to do is we use first is protect your IP, because if you don't have if especially your brand, because that's a must. But then it's really like, what steps can we take proactively to get the business sold? And so, and then I've been working a lot with people that Steve and I are very close with, and we've been selling a lot of e-commerce businesses for really good returns multiples right now. And so I just know the areas, but you got to talk about the areas that are going to hurt you before that's my job, is because I want to have every one of my clients shine like a diamond when it comes time to sell the business. I'd say, dealing with a lawyer should take 5% of your time or less in the business. The other areas, besides this kind of stuff, and I'm getting on a tangent, but I just wrote a blog about having an annual meeting, making sure you're dotting your I's and crossing your T's, even if you're a solopreneur, once a year. And so I'll also send you that, Steve. And you don't need an attorney there, but just make your business look like it shines, even though we all know every business has its own issues. But just keep track of things and log your progress and have your financials look good, and you're going to kill it.
All right, Steve. Well, thank you for coming on the show and just letting people know what's going on. It sounds like this affects way more than e-commerce entrepreneurs, just anyone with an online business, really. And it sounds like it's mainly the usual suspects, California, Florida, New York, and one other state, which I don't even remember what you said. But
and Texas is about texting. So Texas is like, there's certain protocols. If you shouldn't, until you get an opt-in from somebody, you shouldn't be texting them business offers. And so, and it's rigged against the little guy too, which pisses me off. But
all right, well, I'll keep in touch with you and see, and hopefully this will go the way of the ADA lawsuit and follow this under Frivolous going forward. But thanks a lot for coming on.